We think that given the pressures on the family court, family arbitration can provide a particularly important service to the family law community. As a judge, you only have a limited amount of time to read your papers. You may have many other cases in your list. As an arbitrator, you will only have one case in your list on a given day, and you can take as much time as you want to prepare it. You can also communicate directly with the solicitors to ensure that the case is ready. After the case has been heard, the arbitrator can take as long as the arbitrator needs to prepare a full and written judgment explaining the decision that has been reached. At the end of an arbitration, the arbitrator will give a full written decision explaining the outcome, just as a judge will give a judgment at the end of a court case. If a person is dissatisfied with the outcome of an arbitration, he or she may challenge it by applying to the family court. In the event of a challenge of that nature, the court would apply the same principles as it would on an appeal, so the person seeking to challenge the arbitration would have to show that there was a realistic prospect of success in that challenge before it would be allowed to continue. Statistically, the pressure on the family court is demonstrated, I think, by these figures. In 2013, there were 79,000 new private law and financial remedy applications in the family court. 10 years later, there were 95,000 new financial remedy and private law cases issued in 2023. That's an increase of 16,000 new cases a year over 10 years. Quite simply, if that increase were to continue for the next 10 years, everyone who has any experience of the family court can imagine what will happen. It won't cope. The pressure in the family court in private law cases is well known to magistrates who hear 46% of private law cases. Private law cases as a whole are taking an average of 42 weeks to come before the court. For that average figure to be achieved, it means that the contested cases are taking significantly longer than 42 weeks. For many private law cases, settle in the early weeks of the litigation.